So, shall I start?
Yes, ma'am.
Okay. So, good afternoon, everyone. I am Tulika Chaudhary from Amity Innovation Incubator. Firstly, I would like to thank Atal Innovation Mission for the continuous support they have provided to us. We take immense pleasure in welcoming all the participants for our today's session. Legal compliances are born even before the business and keep increasing with the growth of the business. This session aims to showcase the importance of legal compliances, which are often overlooked simply because the startups are not aware of the existing laws. Now, I would like to take the opportunity to introduce our esteemed speaker for the session, Ms. Malvika Bhatia and Mr. Devansh Gandhi. Ms. Bhatia is a management graduate and a fellow member of the Institute of Company Secretaries of India. She is a partner at Blue Lotus Management Consultants LLP. As a practice head, she leads a team over 30 company secretaries, lawyers, and legal practitioners. As a practicing CS, she interprets, advises, and oversees the applications of company laws, labor laws, environment and health laws, besides all HR compliances. Our next speaker, Mr. Gandhi, is an advocate enrolled with the Bar Council of Delhi and practicing before the Honorable High Court of Delhi and various tribunals in Delhi NCR. He is skilled in drafting and vetting of business contracts. His expertise includes advisory under labor and employment laws, arbitration laws. Now, I would like to request the speakers to take the session forward. Also request all the participants to pose their queries in the Q&A section, which would be addressed towards the end of the session. Over to you, speakers.
Good afternoon, participants. So thank you, Tulika, for the introduction. And let's get started with today's session on startup compliances, the right legal guide. So today we'll be covering these topics: business setup, fundraise compliance, ESOP implementation, and essential agreements. The presenters for today, the legal experts are Malvika Bansal and Devansh Gandhi. Malvika, you are on mute.
Good afternoon, everyone. Thank you so much for giving me this opportunity to present my views on the legal compliance, which is a basic framework for any startup in order to flourish and take it to the next level when it becomes a corporate giant, or we call it in the startup sectors as a unicorn. So we'll run through the basic compliances, what most of the people sometimes do miss at the very early stage of when the actual idealization of the idea, or you can say when you start floating around an idea and thinking about which way to go forward. So while I present my views, in case if anybody has any queries, any questions, happy to address at the end of the session. So please do write your queries and we'll be more than happy to address the queries. So Malay, while I present this, I hope you have no issues in forwarding the presentation slide by slide.
Yeah, sure.
Malay, I can't see your next slide.
So could you please enable the presentation mode?
So presentation mode is on. I'll re-enable it. Yeah, is the screen visible now?
Malay, screen is visible, but your entire slides are visible. You have to give it to a presentation mode.
It is on presentation mode.
Right, this is working now. I hope I'm audible to everyone.
Yes, ma'am.
Thank you. So to start with, that first of all, the question arises that which form of an entity or the structure we should incorporate. So there are different options available in the legal framework which the Companies Act provides. The first one is the limited liability partnership. The another one is a one-person company, and the private limited and the public limited. Every other structure do comes with its own pros and cons. Just like the limited liability partnership is also governed by the Ministry of Corporate Affairs, but under the different set of laws, which is not the Companies Act, which is an LLP Act. So here the compliances are very limited. The requirement of partners definitely remain same as of a private limited company, which is two in this case. But yes, definitely in terms of the setup where you are going to have an advisory setup where the multi-level professionals, the different dimensional professionals wanted to join a business stream, this is the best sort of a business. In terms of the compliances is very, very low, very, very limited. So as the compliance involvement is something very, very low. And at a later date, any point of time, in case if anybody wishes to convert it into another site, another setup structure like the private limited company or let's say the public limited company, the conversion options are something very, very smooth. Then we come to the one-person company. Although in the startup sector, the one-person company we don't recommend just because of the reason it is a better form of proprietorship firm, but also not as structured in the way where we can say as a private limited company and the public limited company. Just because of the reason there is no vigilance in terms of the other stakeholders are involved. Only one person is being taken as a director and the one person is being a member. Although compliance requirement is very limited, here is a cap of the Companies Act provides that one person company till this particular threshold limit can be taken as a one person company. And then it has to be converted mandatorily into private limited entity. Now, this word we all are aware of, the private limited entity, because in startup sectors, most of the ideas is being formed and taken shape in form of a private limited entity. So the private limited entity nowadays, thanks to Modi government, I would say, the minimum directors as well as the minimum members as well as the capital requirement become very, very smooth, and the compliance cost, which is about floating of a company, which is 10 years before it could be something around as a statutory fee as a 15,000 to 20,000 rupees. Now it becomes like so simple of incorporating a company in 3 days, and the compliance cost is as minimal as less than 5,000 bucks, which is very, very convenient for anybody. Then in terms of the public limited company, yes, public limited company is also a form of a legal structure where the 3 directors are needed, 7 members are there. But yes, the compliance are in addition to the private limited company, here are number of compliances which needs to be adhered to. So this is something not a very favorable version in terms of going for a startup sector. So moving on to the very quickly in terms of the advantages of the private limited company, as I already mentioned that lesser number of directors and members in comparison to the public limited company. Then also the private limited entities is also getting an exemption under the Startup India scheme, which public limited entity does not qualify to become startup. So here I would say, in terms of when we are looking as a manufacturing process or the larger vision, we can definitely look for a public limited company, but not immediately in terms of when the business is at the stage of like development stage. Then in terms of faster decision making, because lesser number of shareholders involved, lesser complexity is involved. So lesser number of stakeholders will bring lesser number of complications, one can say. As I mentioned, that the compliance cost, definitely it's related to and directly attached to the authorized share capital of the company, but definitely in terms of comparison in between all of the entity structures, private limited companies has a very lesser compliance cost. Regulatory supervision is limited. I will not say it is not there. Yes, definitely it is there. But nowadays, the filings, every other, even while you are sitting in Delhi, you can do a filing for Karnataka or let's say Kerala or any other state on the pan-India base. So it's not that you need to go and being in a queue and then do file. So this is something very, very easier mode and smooth nowadays. Transferability of shares, this is something which private company has a very greater feature in terms of the public limited entity. That transfer is something very easy because there is no restriction per se. There is a restriction in the law, but there is no restriction in terms of the valuation, not in terms of the too much of complication arises. So let's say if you have a buyer of your share and you wanted to exit at any point of time, it is easier way to exit because in most of the times we have seen that the startups is being formulated with an idea. After a few years of time period, the promoters wanted to, co-founders wanted to exit and they want to start something new. So this is a very easier form in that way. Similarly, the funds can be very easily infused by having a little amount of, you can say, capital injection in terms of giving a right in your company, and that also bring a vigilance from the third party that who are pioneer in their business. They can also guide you to flourish your business. So this is anyway is a good form in that way. So very quickly we'll take you through what are the compliances in terms of the private limited company, which is an essential compliances per se. So I have divided this into two parts. One is regular compliances and one is on the event-based compliances. So event-based compliances will only trigger when there is some event happened. But let's say if anybody says, okay, I have an idea, but I don't know whether COVID again happens, anything again has happened as a calamity, then will event-based compliances also going to trigger? Is it also add to my compliance cost? So no, that's not the case. In this case, regular compliances, definitely the people have to adhere to. And we always suggest co-founder at the early stage, please do adhere to all the regular compliances so that when you go for a larger fundraise, you go for a large vision, when actually your due diligence happen, you will be proved to be very compliant and you can have a good night's sleep, I would always say. Because if you are compliant enough, there will not be any repercussion in terms of any non-compliance, any notices from any authority. So in terms of the regular compliance, these are the regular compliance which has been displayed here, which you have to hold board meetings, which is 4 board meetings in a year, 1 general meeting, which is an annual general meeting, filing of annual returns, your financial statement or your annual return every year. Then being a director, this is something very important, as a KYC has to be updated. So just like the banks, MC also comes up with a special section in the act introduced as that all directors have to mandatorily complete their KYC. In absence of doing the KYC, the DIN is going to be deactivated and they will be later on disqualified as a directors as well. So auditor appointment, yes, private limited company, doesn't matter whatever the threshold in terms of the turnover, they have to mandatorily have to have an audit, which is not in the case of LLP. LLP, there is a threshold, then only the statutory audit comes in picture. Filing of income tax return, definitely once a year you need to file, just like the proprietor or as an individual, you file your income tax return. You need to file these returns as a regular compliance. Then GST returns, we most of the time we address these queries that some people says ki if we are not having any business per se, let's say we have very limited invoice, will the GST still comes in? Yes, so these are two taxation. One is the direct taxation part and another is the indirect taxation part. In terms of the Income Tax Act, which comes as a direct taxation part. And in terms of indirect taxation, yes, you need to file your GST return in case if you have a GST registration number. Even if you don't have a GST registration number, but if any vendor is giving you their invoices, then also under the reverse charge mechanism, you can have the benefit of GST. So we always advise clients that please go ahead for the GST registration. Then event-based compliances like FEMA Act compliances, FEMA will only kick in, let's say, if you have the foreign investors in your company, whether it is an angel investors, whether it is an individual investor who is sitting abroad, or let's say any director. RBI comes in picture when your company is more into the financing sector. It could be in NBFC, it could be in housing finance. Then the RBI will also comes in picture. SEBI comes at a later stage when the related party transaction starts happening. Similarly, if the private limited company is in the business of insurance, that they have to comply with the IRDA regulations. Labor-related compliances will definitely kick in whether you do a contract manufacturing, you outsource your manufacturing process or not, because your ESIC, your PF, your all these compliances, which is an employee-related compliances, will definitely be there. Factories Act only will come in, let's say, if you have a manufacturing unit, or any other compliances depending upon the size, operation, and the structure of an organization as well as event. Because in India, everybody is aware of that once you start anything new, you have to look at it from all the legal perspective, that what are the compliances going to trigger. So, but this is something we are just taking very briefly in terms of what is in terms of that. So this is something very interesting. So most of the people feel that even if we float a company, there is no risk involved because if we are not doing any business, there is no risk. No, it is not like that. So even the businesses, so I have divided it into three parts. One is a high risk where the criminal proceedings or the closure of business, or let's say the civil, not the criminal liabilities are there, which is very high in fines or penalties. So these are few sections. Let's say if you don't start your business within a 1 year of your incorporation, then in that case, the business is definitely going to be closed. Similarly, there are few sections where the criminal proceedings is started, which is where the central government, in case if any frauds happening, in case if you are tampering with any records, or let's say any false statements is being presented. Similarly, there are few sections in the Companies Act which says that you have to maintain certain register and records. So we always call these compliances as three parts, which is an external compliances, which comes under the high risk category, internal compliances, which comes as a moderate risk, where you need to maintain certain register records and time to time you have to report them, and low risk, where it is more of a self-governance nature. You just need to give it a fine and then you are go away with it. But even if when you pay any fine, your default remains there. You can make a default good, but definitely the non-compliance in your books and the records will remain there. Similarly, in other acts as well, there will be different penalties. So very interesting with regard to very quickly take you through the fundraise compliance, because most of the time when we approach to any incubator center or let's say any angel investors, we really wish to understand that what is the modes available to us. So these are the brief modes. One is a bootstrap, definitely, which anybody as a co-founder at the initial stage investing from his own pocket. Friends and family, incubator and the accelerator support, as we are being very lucky to have Amity and a lot of incubators nowadays in that way where they are supporting startups. Then pitching competition, where you can compete and give these awards, which is something a very minimalistic awards that can be win as a cash prize or the investment capital, and that can be taken as a grant. Then bank borrowings, which is not a very suitable option for a startup because they always ask for a security. And generally, startups don't have the security per se, so they cannot approach bank. Angel and institutional investors, again, this is something depending upon your scale of business, you can decide on which series of funding you can go on. And similarly, the private equity. these are the few instruments through which the startups can raise funds within their company. One is equity, definitely. The another one is a convertible instruments in the form of compulsory convertible shares, or let's say the debentures in that way. Then debt instruments, in case if you don't want to dilute your capital investment at the very beginning, the co-founders can go ahead for the debt investment in that way, and they can raise the debt. Definitely the cost of investment of debt is higher than the cost of equity or any convertible instrument, but this gives you an opportunity to keep intact and keep and hold on your entity. Then this is something, a very new concept comes up, which is in CSOP. We call it as a community subscription offer plan. Here, immediately CCPS is, or the CCD is not being issued, but yes, a contractual agreement happens in between two parties, and depending upon that, the money is being streamed. And at a later stage, whenever the transition of money happens, at the time we end up paying them and issuing accordingly the security. So this is a very brief process of fundraise. First of all, yes, you definitely need to value your entity, that at wall valuation, what is going to be your cap table. So this is something, a juggling part at that time, where you are deciding on that. As far as I am concerned, if I would be having an X amount, I will be able to raise this company to this certain level. So that is going to be your valuation at the initial level. Then once the valuation is being decided, which is an enterprise valuation, we say, and then your share price accordingly is going to be decided, then you may go ahead into agreement drafting within SSHA and everything, where you can define your terms in terms of what the rights and the responsibility you wanted to share with your investors. Then you conduct meetings for board meetings and the general meetings for issuing your offer letter. Offer letter is being circulated to the concerned individuals. They can, depending upon their investment and the promise amount, they can accept the offer and do infuse the money. Once the money is being infused, again, the company has to do the secretarial compliance in terms of holding board meeting and general meeting. And then accordingly shares is being issued, and or the shares or the instrument, whatever the case may be, whether it is CCPS, whether it is CCD, or whether any debt instrument. Then this pass-through filing is something very, very important. And I will advise all the participants here, whenever you are raising any funds, please be ensured that the money hit properly in your account. You have seen it once in your bank statement, then only go for pass-through filing. And post pass-through filing only, please start utilizing the fund. Because Companies Act very clearly states, in case if you are utilizing the fund before the filing of pass-through, that is a complete void transaction. So this is something a very critical part, because most of the time we are in a rush at the time that we generally utilize the fund. And I always tell the incubators and the fund investors that please do only circulate the money, infuse the money when only the call for monies is being sent, which is generally after issuing the offer letter. Once this is being done, the company has to issue the instrument. In the private limited company, that gives you an option. You can have it in a physical form. So the accordingly share certificates will be issued, and due stamp duty on the shares, depending upon which state the registered office is, to be paid. So this is a very brief process. Definitely there are very ifs and buts within this process, but this is something very, very brief in terms of that. In order to justify the significance of each of these steps, we just identified and mapped certain risks of these missing any steps herein. So very quickly, valuation, in case you are not going to get the valuation report done, then there is this penal provision which kicks in picture, which is a penalty of 10,000 rupees, and then continuation penalty of 1,000 rupees per day. Then misstatement or the false statement in the offer letter. Ministry of Corporate Affairs do define a process, and as well as a complete format of the offer document. So it is something very, very important to go ahead and look at it, that what is an offer is being given, and even from both the side, the startups which are asking for the money and the investors who are investing the money. So this becomes a critical document from both sides, because it brings a criminal penalty as well. Similarly, as I already mentioned, that the consequences of non-filing pass-through. So you can see here the fine is up to, it can exceed to 25 lakhs, which is a very, very big amount. Mala, can we have the next slide? In case if we do accept the funds in any of the contravention of the provisions of the act, then the company promoters as well as the directors in the startups, we can say these two terms, which is promoter and directors, are generally common at the initial stage until and unless you have an investor director on board. So here again, the penalty is something very, very high. In terms of private placement, you end up having a penalty of 2 CR, which is something very high. And in my own experience, I have seen many deals in that way going ahead for the negotiation stage, because the DD process comes up with an n number of irregularities in this fundraise process. And I would like to add one thing here in that please do understand that once these filings and everything is being done, especially the PAS 3 filing, which is in filing of a capital, immediately your portal will accept it and your capital will be raised accordingly. And once it's done in a wrong way, damage has been done. Nothing can be done until unless you approach to High Court. You have no option going to any authority, so no consultant can change this or deregularize this, what happened in the past. So it's always a good idea that please do all these compliances while doing the fundraise in a proper and very professional manner, I would say. In case if you are having a foreign remittance, then delay reporting of with RBI definitely comes up with the penalty, and that penalty is with RBI, and that can something from you can say 50,000 rupees to 25 crores as well. Then the delayed payment of securities is 10 times of the stamp duty. So you may imagine, like, let's say for a lakh rupees, you need to pay only 100 rupees as a duty. But once you forget about paying the stamp duty, you end up paying 1,000 rupees, which is of no use. And then you also need to lagao chakkar to the authorities. So that doesn't make sense. So generally, whenever we define the cap tables at the initial stage, we have to talk about the ESOPs, because in the ESOPs, even the investor sometimes in their term sheet says that you have to carve out a ESOP from your own cap table so that the later dilution doesn't happen. And similarly, even from the company perspective, in order to retain the right talent, they need to roll out ESOPs. So I very quickly, briefly run you through from the ESOPs process and the structure. So there are two alternatives available under the ESOPs. One is a direct route. The another one is the indirect route. The difference in between these two routes is in the direct route, only the ESOP pool is being created. There is no trust structure. Trust structures are generally beneficial for the companies which is larger in size, or let's say their pool size is quite larger and they have an intent to immediately grant to a number of employees. Because we have seen at the early stage, startups don't have an employee. So they really don't wish to grant, and they don't know at what stage they are going to do the grants. So they will stick to the direct route. They should stick to the direct route instead of going ahead for the indirect route. But in both the cases, the difference in terms of the investor is that in case of the trust route, the dilution doesn't happen. Just because in the books for X number of shares, which is lies with the ESOP pool, that is in the name of trust. So you can say, let's say X company is there. So X private limited ESOP pool. So similarly, X private limited ESOP trust. So in the register of members, where entire register is also having the details of other shareholders, there is a one name is also being reflected as a ESOP trust. So there is already a shareholder which is already in place. So there is not going to be any further dilution when actual allotment happens, because transfer of holdings happens from trust to that particular person. But in case of pool, definitely it is going to be allotted as a capital. So there is a very minor dilution. Sometimes it happens. That is the reason we make the tables as a cap tables as a fully diluted basis, just to give a right picture. So these are brief stages in ESOP implementation. That first of all, definitely the pool has to be created. Generally in the private limited company, from 5% to 15% pool is being created, because in the listed company, there is a restriction of not beyond 10% you can hold the pool. And then approval of board, and you have to draw a complete scheme. So there is going to be a complete scheme which defines all your eligibility criteria, then when it's going to be grant and everything. And that scheme has to be approved by the board and definitely by these shareholders, because they are the ultimate stakeholders to whom it is being affected. Then ESOP is being in case if you have an employees and you have a ready employee, then you may grant it. So these are the few terminology, which is grant, vest, and exercise. The grant happens immediately, but yes, the vesting starts only after a 1 year is being elapsed from the grant date to the issuance from the grant date. So you can say if the grant is 1st April 2022, so the first vesting is going to be started on or after 1st April 2023. And here you have an alternative that you can vest the entire shareholding. Let's say if you grant 500 shares to a person, Mr. X, you can grant the entire shareholding and the vest it immediately, or you can do the vesting in a graded fashion where you can say, okay, in the first year of service, only 25% of the total options is going to be vest, and so on. And later on, when the actual exercise happens, so it is an employee right, he can decide whether I wanted to exercise it right now or I wanted to exercise it at a later date. So, but yes, your ESOP policies can cover all these things, and which is your scheme and the critical document in this case. So this is very brief advantage of having an ESOP scheme. ESOP scheme give a very, very transparency in terms of what you are giving to employees. Because while you are hiring a talent in terms of showing them a picture for a future date, it's very important for you to be very transparent with them so that they could align to organization vision. So ESOP policy comes in picture and plays a role at that time where the exact terminology, all these eligibility criteria is being defined, and clear framework is being defined that how is the allotment happens, at what price it is going to happen. So there will not be any ambiguity in terms of what is being promised to employees and what is being granted to them. And well-defined procedures where they know exactly, let's say if the promoter wanted to exit at any point of time, where would they go, whether they would be tag along with them, whether they are not going to sell, what is an option available to them. And similarly, it also talks about, let's say if anybody to resign or you terminate anyone, then what happens to those shares, what happens to unvested shares. So this is something, a very good tool in terms of employee retention and the motivation at a longer run, because startups also don't have too much of money in order to part ways. So this gives an opportunity to a startup to hold them for a future vision. So that's all from my side. I will request my colleague to take you further for the essential agreements required by the startup. Thank you so much.
Thank you, Malvika. It was indeed a very knowledgeable session. And I guess all the startup founders and the people who have joined the presentation have gained knowledge on the essential compliances for startups. So I'll begin with the essential agreements that are required by a startup. So basically, before we start a business, the founders of a company, when they are into a prototype model, they want to develop something. Instead of setting up a company, they enter into a co-founder agreement. So as per this co-founder agreement, they can decide on the roles and duties, the investments they want to make, and later on plan on either setting up a company or what type of company they want to set up. After that, once they set up a company, they can also raise funds and investments, and other shareholders join. They can issue a shareholder agreement, which will definitely which will mention the detail about the ownership of shares, the rights, obligations, and protection of the shareholders. And during this entire process, they'll have to enter into a non-disclosure agreement, either with the consultants or with the employees or with the other co-founders, so that the prototype that they're trying to build or the confidential information either of their clients is protected. In the similar manner, they can also enter into a non-compete agreement, which will protect the business and the employees and the employer, basically, so that any employee or a co-founder doesn't quit the company and form a separate company, and it'll protect the intellectual property of the company. Similarly, when they may also issue employment contracts to their employees. Now it is also going to become mandatory to issue employment contracts after the code on wages kick in. So they'll have to issue these employment contracts which detail about the name of the employee, the key responsibility areas, the salary structure, and everything related to his abandonment of duties, term of employment, and the way of termination of employment. Similarly, for consultant agreements, because startups usually don't take employees initially, they enter into consultancy agreements with the consultants who are basically freelancers or who have expertise in their area. So the consultants agreement will definitely detail about the terms of the and roles, duties, responsibilities of the consultant, the term of the consultant agreement, and the termination of the same, and the consideration that is involved between the parties. Similarly, the startups can enter into various commercial agreements, which are maybe joint venture. They can enter into a joint venture with other company, wherein they will detail about the roles, duties, responsibilities of one company and the other company, and share the revenue sharing model or a commission basis model, and other duties and responsibilities of the agreement. The other agreement is memorandum of understanding. So basically, this MOU, I've received a lot of questions from startups wherein they detail that are these MOU enforceable or not. Definitely, these MOUs are enforceable, and if you pay a proper stamp duty on these MOUs, it is signed and executed by the parties. Definitely, they are enforceable and can depend on business to business. These MOUs will detail the roles, duties, and responsibilities of the parties and the risk associated with the transaction of the business. Then there is software as a service, which we call SaaS agreement. This is basically when a vendor who is also a software service provider enters into an agreement with a business owner or with a startup, wherein we'll have to protect the rights, we'll have to detail how the data is used in the software, and what happens suppose if a software malfunctions or anything like that. Who is going to bear the damages in such a scenario? Service agreement is basically, which we also call master service agreement. It is a agreement wherein the business owners enter into with a service provider who's providing some services to the company. It will again detail the roles, duties, responsibilities of the organization. And similarly, for this vendor agreement also, the roles, duties, responsibilities of a vendor are detailed. These vendor agreements basically relate to goods and services, the people who provide goods and services to the company or to the startups. Now, coming to the franchise agreement, basically franchise agreement is done to not only promote the businesses, but also to protect the intellectual property or the brand name of the business, so that a franchisee doesn't manipulate or misuse the brand name of a particular business. Next. Yeah. Now, once the company is set up, the another aspect is the making of policies for a business. So the basic policy which will govern all the employees is the HR policy, which we also call HR manual or employment manual. It basically contains all the details of services of an employee with respect to the employer. It will detail and set out very clearly what is the vision, mission, and guiding principles of the business. It will include not only the probation policy, but leave policy, termination policy, POJ policy, maternity policy, which are mandatory as per law. And apart from this, it also details about the travel policies of any employees and anything related to the service rules, basically. Then there is an ESOP policy, employee stock option policy, wherein the company tells that we are setting up such a scheme and we'll issue such and such shares to any employee, how the shares will be vested, granted, and exercised by the employees, and in what manner, and who has the right to first purchase of those shares. All these things are mentioned in the ESOP policy, basically. Then there is website and digital policies. So there it contains terms of use. Terms of use is basically a contract between a user of a website or an application with the developer of that application or the business who has built that website. So it is a mandatory procedure under law to issue terms of use. Similarly, privacy policy also contains the same things. It contains how the data is to be protected, how the data of the user is to be used, and how the user may not misuse the data of other users, or how a user can protect his data. It totally details the data protection rules in the privacy policy. Then there are disclaimers. So again, it is mandatory under laws that you inform the users of a website or an application that we'll use your data in such and such manner, or these are the certain terms that are governed between us and the user. And there are commercial terms and refund policy. Now, refund policy clearly details what happens if a user has paid some amount to a website or an application for any service or for using that website or service, and in what manner will that amount be refunded if the transaction is basically cancelled, or if the user doesn't want to proceed with the transaction. It is very important to draft the agreements in a proper and concise manner, because under the Indian Contract Act, it clearly says that if there is confusion or if a contract cannot be determined or interpreted easily, the agreement is void. So the main importance of a well-drafted agreement is that it lays the foundation of any transaction. Basically, it records all the transactions that have to happen between the businesses, and it acts as a risk management technique for a future date. And it also contains the dispute resolution mechanism. So in case there is a dispute between the parties, they can obviously beforehand have how to resolve the dispute. It may be either through mediation first and then going into arbitration, or directly going into a court and then getting the terms interpreted and enforcing the specific performance of a contract. So it acts as a legal proof of any transaction. Suppose if there is no contract, obviously, then it is difficult to provide any evidence to the court or to resolve any dispute. It provides a financial warranty to any of the party who is not comfortable with the agreement. So if a party has breached the terms of any agreement, the other party may claim damages. And it also discusses about the future of engagement of the transaction between the parties. The risk associated with the poorly drafted agreements. So if an agreement is poorly drafted, or if in case there is no agreement between the parties, it may lead to major complications and chaos, because until and unless the terms are properly interpreted, well defined in the agreement, then it will lead to major complications. The parties will keep on fighting on the interpretation of the contract itself. And obviously the contract should mention the proper plan for solving of disputes. And ultimately, if there is a dispute, the resources of parties, basically time and money and human resources, wasted in resolving those disputes. And all these things are basically the resource of a startup. They cannot waste all these resources in resolving any dispute. And in a poorly drafted agreement, there may be a term which may be adverse to your business, and you may unknowingly accept it. So the agreement has to be properly drafted and vetted as per law. There are a few regulations related to salaries, pay and allowances, which basically are governed under the Payment of Wages Act, Minimum Wages Act, Equal Remuneration Act, Payment of Bonus Act, and Jobs and Establishment Act, which is applicable to respective states. So under the Payment of Wages Act, it basically regulates payment of wages to an employee, how the wages are to be paid, and the remedy if in case there is any unauthorized deductions from the employer. It also authorizes the employer to deduct any amount from the wages, but there are certain limits to that deduction, which is mentioned under the Payment of Wages Act. Under the Minimum Wages Act, the government issues notifications from time to time concerning the inflation rate, that what is the minimum wage to be paid to a skilled employee, to a semi-skilled employee, or to a daily earner, and the work hours are fixed. So the employer must adhere to these notifications, which are issued by the government from time to time under the Minimum Wages Act. And there is Equal Remuneration Act, which says that wages for a particular work and of particular nature should be same for male and female employees. You cannot discriminate between male and female employees, and you cannot discriminate on the basis of wages to them. Also, in the case of transfers, training, and promotion, you'll have to maintain that the male and female employees are treated equally. Similarly, under the Payment of Bonus Act, which is applicable where there are 20 or more workmen, it is a duty of the employer. Mandatorily, will have to pay the bonus to the employee whose wages do not exceed rupees 21,000 per month. Now, Shops and Establishment Act, which is applicable to different states. So all these states have different Shops and Establishment Act. It provides for regulations for payment of wages, terms of service, work hours, rest intervals, overtime, opening and closing hours, close days, holidays. Apart from this, it also provides the notice period if there's nothing mentioned in a contract. So you'll have to all these startups operating in a particular area are also governed by the Shops and Establishment Act of the particular state. Thank you so much, Malay. If you could proceed.
Thank you, sir. Thank you so much, Ms. Malvika and Mr. Devansh, for sharing such valuable information for our young budding entrepreneurs. Amity Innovation Incubator is organizing this session in partnership with Easy Legal. Easy Legal is an AI-based legal technology platform. It provides legal consultation to individuals and small businesses through a prepaid recharge model. Customers can top up their wallet with talk time minutes and consult an expert lawyer. Consultation with a lawyer delivered on demand. Easy Legal is led by Mr. Malay Mandal and Mr. Nitin Nijhavan. Malay has worked in an Indian legal space for more than 10 years. He has experience in leading growth, product development, and revenue in fast-growing digital startups. His passion for simplifying legal led to the formation of Easy Legal with his friends and now a co-founder. Nitin is a technology enthusiast and Easy Legal is his second venture. He is currently based in US and has experience in leading large global teams for technology development. Now, I would like to request Malay to take the session forward.
Thank you, Tulika. And good afternoon, friends and fellow founders. I'm happy to present Easy Legal to all of you and walk you through how we can help meet your startup compliance or your business compliance requirements. So Easy Legal is on a mission to make legal simple. We want to simplify legal. You know, we've all gone through that complicated process of approaching a lawyer, paying hefty legal fees, and chasing the lawyer to get that agreement draft that we want, or the business registration that we intend to, the license that we intend to get, or even take a legal advice from the lawyer related to law and regulation governing your business. So what we've done is we've created a legal technology platform where we've standardized the products. We've made the service delivery so very conveniently accessible. And by way of, and at the supply side, we have more than 2,000 corporate lawyers aggregated from the different parts of the country. And all of these are subject matter experts, either be it in, say, providing you with legal advice or drafting your documents or, getting you that business license that you would require or handling your compliance work. So the customer, so we have these 4 entities that play a role in this entire platform service delivery exchange. There's a customer, which is you. We have an Easy Legal marketplace where where the customer comes, chooses the service that he requires, makes a purchase, and the moment an order is created in the system, it's allocated to one of the expert lawyers. The lawyer delivers the service. The customer can keep a track, can track the service delivery progress. We work on very strict timelines. So within those timelines, stipulated timelines, the service is delivered, and post delivery of the service, the customer rates the lawyer. So what we offer is bite-sized legal services. So we do not push or push a customer or a small business into doing multiple things. We only offer what service they require or what has been advised by the lawyer after they've taken the legal consultation. So all our services are bite-sized legal services, which has a standard price, which is quite an affordable price, and has a stipulated timeline for delivery. And so you take a service, you book an order, the service, it's allocated to a lawyer, the service is delivered, and you rate the lawyer for the service, end of service. So, if that is what we offer. So we offer services under three categories: legal advice or consultation, as we call it; legal documents, in which we offer document drafting or document review. So say, for example, if you got a term sheet, you want to get it reviewed by a lawyer, you have your questions to check with the lawyer, you can talk to an expert lawyer, get all your questions answered, so that you know what are the terms offered to you in the term sheet and whether you should go ahead and accept the next funds that you are is awaiting you. Then comes business registrations. All forms of government registrations and licenses is what we help you with. Say, for example, you want to set up a private limited company, or you want to get your trademark registered, or you want to, if you are in a food business, you want to get your FSSAI license, or any form of registrations or license service we offer. Uh, we are a technology enabled legal service delivery platform, and that helps us in maximizing our reach. We are able to keep the cost of the service low, the outcomes are defined, it's very transparent, you can have a full view of the service delivery progress, the quality is high, and it's very easy and convenient to use. So we have two kinds of offerings. One are the standard offers, standard products available on a website, which is one product, one price, a la carte menu. You can choose any product that you want, or if you don't see any document or service that you require on a website, then please call us, contact us by way of WhatsApp, email, phone call, and we'll be happy to explain you how that service would be delivered, get you the right legal advice, and help you execute that service, be it a document or be it any kind of registration or license. But then there are startups which require a few services. So for them, we have customized packs that we offer, in which these customized packs helps reduce the cost. If you had to buy each of these service individually, then the price would have been higher. But if you buy it in the form of a pack, the price is lower, and these have longer validity, so you don't have to consume all the services the moment you bought it. So each pack would have a validity of 6 to 9 months, depending upon what all items you've chosen. So say, for example, our business setup pack, in which we give a private limited company incorporation, GST registration, MSME registration, and Startup India registration at just 14,999. And private limited company incorporation, we are offering only at 7,800. If you approach a CA directly, nobody would, charge you less than 15 to 20,000 plus GST, but that's the kind of price that we are offering. So we've been able to bring this, offer an affordable costing because of our widespread use of technology, being able to create a large marketplace of lawyers. We've been able to give them enough, compensate them enough to be able to, offer these services at a lower cost. The quality would be high. There would be no compromise on the quality. And we being a startup ourselves, we understand, the budgetary constraints with every startup, and that's the gap that we're trying to fill in here. And to avail any offer, any of these that I showed here, or any other offer that you would want, please call or WhatsApp us at 8588887480, or email us at contact@easylegal.in. On our website www.easylegal.in, if you visit, you'll get these contact details right there. Reach out to us, and we'll be happy to help you with any of your legal and compliance requirements.
Thank you, Malay. And thank you for sharing such valuable information. And we look forward to interact with you down the line for more interesting session like this. And we'll be taking all the queries offline, as Malvika ma'am has already answered few of the queries from startup in the Q&A section. So now I would like to invite Mr. Sagar for a vote of thanks. Over to you, Sagar.
Thank you, Tulika. On behalf of Amity Innovation Incubator, I would like to thank, first of all, the speakers of today, Ms. Malvika ma'am, Mr. Devansh, and finally, I would also like to thank Mr. Malay and Mr. Nitin, the founders of Easy Legal. We hope that the attendees found the session insightful, and to the founders, I would say thank you for taking out this afternoon, as well as to the lawyers who spoke today. Thank you for taking out this afternoon and speaking to our attendees. I'm sure there will be some questions, and we'll reach out to you with the questions. Thank you so much once again from Amity Innovation Incubator.
Thank you. Thank you, Amity, for giving us this opportunity to present today in front of the fellow founders and the startup fraternity. And any questions anybody has, we would be more than happy to address them. Please reach out to us. As I said, call us, WhatsApp us on 8588887480 or write to us at contact@easylegal.in. And we will get back to you with an answer at the earliest.
So much. Thank you so much, Amity, and as well as the people who are being joined here. Thank you so much. And thank you for my fellow professionals. Thanks a ton for giving me this opportunity. Thank you.
Thank you so much,
Thank you,
everyone.
ma'am. Thank you.
Thank you, everyone, and wish you a very happy Diwali.
Same to you, ma'am.
Thank you.
Thank you, ma'am.
Thank you.
Bye-bye.
Bye-bye.